Hello and welcome to this week's Fact Friday, where we are again joined by Bracious associate Catherine Morgan. So, Catherine, perhaps you could explain to our viewers this week what we will be discussing.
Hi, Michael. I thought it might be useful to just give some general advice about what happens when someone dies and leaves behind commercial property or a portfolio of properties. Um, More people than you would think that are individuals have lots of properties. Do you come across this quite often in your team?
We do, yeah. More so recently. I think the best, without going into too much detail, the best way to sort of set this out in accordance with your wishes is just simply prepare a will dealing with the assets that you have, i.e., the property.
And I mean, sadly, in the current pandemic, we've had surges of requests to assist on matters where people have died, leaving behind multiple properties.
Which brings me on nicely to our second question today for you, Catherine, which is please can you set out the initial points for the executors to think about?
Yes, well, hopefully the deceased has left a will which validly appoints executors. By law, the property will pass to the personal representative, so there's no immediate rush to have the properties transferred to the executors' names. It is advisable to do this sooner rather than later, as it just makes it easier to deal with the properties going forward. It's quite simple applications to make to the land registry to do that transfer. The estate then has to be dealt with in accordance with the will. Depending on what is going to be done with the properties, it's good to have up to date probate valuations. Valuers can also be useful in advising the beneficiaries what to do with the properties, whether to retain them and continue to let them out or to sell them at auction if there's some title problems or problems with the existing tenant. If the properties are let to occupational tenants and that is going to stay, you need to serve notices on the tenants, informing them about the change in the landlord. And probably the estate will be, if the solicitor is acting on behalf of the state, the rent will then be sent to the solicitor's client account because it will be collected for the benefit of the estate. So the tenants, it's important they are notified of the change in account details so they can continue to pay rent in the normal way. It's also important to continue to manage the properties and to make sure things that aren't missed, such as dealing with rent reviews, if tenants have served break notices, and most importantly, to ensure that the properties are continued to be insured. So it's good to just have a check through the insurance policies and take note of the renewal dates, because that will be a landlord covenant in the lease, which the executors are assuming the responsibilities of. Um, if the properties are going to be sold, then it's vital to ensure that the paperwork is up to date and in a form ready to be produced to the buyer's solicitors.
Excellent, thank you. And our third and final question for you today, Catherine, which is are there any pitfalls or issues to consider?
Thinking about kind of general issues is the first would be if there is no will, or for whatever reason there's no current executors, they can't act, or they haven't been validly appointed. In that case, you need to get expert advice from a private client solicitor to help with that. The second point can be if there are disputes as to what the beneficiaries want to do with the properties, particularly if the estate's been left equally or there are multiple beneficiaries. And they might then need the consent of the executors before dealing with the properties. And this is particularly prevalent where there is a trust and properties are left in trust. I dealt with a matter a few years ago where the son of a lady in a care home who had severe vascular dementia, he wanted to sell one of her properties to assist in paying for her care home fees. The executor was an elderly retired solicitor that we had to track down. Because the property was in a trust, his consent was needed to the sale and he wouldn't consent to it. So that created a real issue that we had to resolve with the private client team. Um, I've said if there is a trust, generally, we need to look at the position before doing anything with the properties. And also, you need to consider getting accountant's advice quite quickly, because there will be tax implications if the beneficiaries want to keep the investment properties and continue to let them. Because if you're receiving rental income, you need to think about income tax, and also capital gains tax if you're going to be selling the properties. But again, you need to seek specialist advice on this. So that's basically a general overview when you're dealing with commercial properties left by a deceased. But it's much more detailed than that, and we would recommend that legal advice is sought as early as possible from both property lawyers and their private client colleagues.
Yeah, of course. And if you don't have a will, please do get in touch and we can, of course, help you with this. Catherine, it's been a pleasure having you on Facts Friday. Hopefully, see you again in the not too distant future. If anyone has any questions, please do either pop them in the comments section below or get in touch with either Catherine or myself. And I hope to see you soon. Take care.
Thanks.